Hello and welcome back to another live conversation to ask the many questions that are racing through your minds right now related to human resources, leadership, and employment law. And this is a live conversation. So if you guys have any questions right now, please feel free to comment, to add them into the comment box below. So in that way we can answer your questions throughout this conversation here. And we have a very special guest that's joining myself and Olivia today. We have Stuart Rudner from our partners at Rudner Law with us to talk about employment law. Stuart is joining us today with a very timely topic now that some provinces are preparing to reopen. So Stuart's here to talk about everything in terms of employment law and to help us prepare for what we've learned from all of this. What can we do now to prepare to reopen, and how can we future-proof our business? So thanks so much, Stuart, for joining us today. Really appreciate your time jumping on here on a Friday morning.
Yeah, no, thanks for inviting me. I'm really looking forward to the conversation with you and Olivia. It should be great. You talked about a whole lot of topics, which probably could fill a week, so we'll do our best in the next hour, but it should be great. And I think this, the COVID-19 crisis we're going through, it's a great wake-up call for a lot of employers and employees. And just by way of quick background, I've been practicing law for a little over 20 years, most of that time focused on employment law. I've now got a firm with an amazing team, and all we do is employment law. And we work with employers and employees, so we do see both sides. And we do happen to have a particular focus on healthcare professionals and dental practices in particular. So we've worked with a number of practices across the country, aside from Quebec. The laws are a little too different in Quebec. But aside from that, we work with practices across the country, and we see the challenges that they go through in the best case scenario. We also know what everyone's going through now, where most of our clients are either shut down completely or they're basically operating on a skeleton staff. Although, as we were talking about off air, hopefully some will start to open up in the next little while. But it's a great wake-up call because, what I've always said, and it frustrates me to no end, is most of the dental practices we work with are great at what they do, but they don't take the time to adopt a strategic approach to HR and to employment laws, and they don't protect themselves, and they also don't give themselves a strategic advantage. So now might be a bit of an opportunity as well. So I know you talked about learning lessons learned and future-proofing yourself. I know we'll be able to talk about some of that. So I think it's a great opportunity.
Yeah, exactly. And I know that you've been busy working with practices all across Canada lately, navigating and answering all of their questions during these uncertain times. But what are the top 3 questions that you've been hearing or getting most from these practice owners?
Yeah, I'll actually, before I get to the top 3, one point I wanted to make, because this is so important and it's often overlooked. And I get it. Most business owners are focused on a lot of things, including at this point, just staying afloat, basically. They're not thinking about employment law. So I think it's important to remember 2 things. One is any decision that you make to reduce your labor costs obviously has an impact on your employees, which creates that tension and potential for a dispute. It's also important to remember that you may think of the people in your office as your staff, your team, etc. But every employment relationship is a legal relationship, and everyone comes with legal rights and legal obligations. And it's critical to be aware of those as you make decisions. And that's when people are not aware of them. That's when the cases come through our door, or our virtual door these days, where there are wrongful dismissal claims and other claims that are made because no one ever took the time to think about legal implications before they made a decision. So that'll be my overall message, which I'll probably come back to at the end. But to get to your question, top 3 things. Yeah, I couldn't limit it to 3, so I actually had 4. The first one was, how do I cut labor costs? And we can talk about that. And then, as I mentioned to you, there's slides up on the screen. I have no intention of going through a formal presentation, but there are things we can talk about. So first question is, how do I cut labor costs? Can we look at things like layoffs, salary cuts, wage reductions? Is there government assistance? So that's question 1. 2, a lot, of course, of dentists own their own practices, and they may have their spouse involved, but they may not be on payroll. So what support's available for the owner, for the owner's spouse, and other non-arm's length people that may be involved? That's the second one we often get. Third, it kind of relates to the first, which is, can we lay people off? Do we even have the right to? And that's a very contentious point that I will definitely come back to. And my fourth was what happens when we reopen. And it's been really interesting to see, and I think you guys may have seen this as well. You know, the initial discussion was all about layoffs. And then we kind of shifted to the wage subsidy, which I think is a real game changer. But now a lot of the questions I'm getting, and I think you guys as well, is what happens when we can reopen, and how do we deal with safety? Do we have to bring everyone back? What do we do about contracts? So those are my top four, and I guess we can get into more detail on some of them as we go.
Yeah, no, I mean, those were all really, really great points. And we've been getting the same type of questions as well. And like you said, it's definitely shifted from 6 weeks ago when all of a sudden we were mandated and the decision was made for us from the government to close the doors. And then all of a sudden we were left with figuring out and making these tough decisions. And if these offices didn't have contracts, employment agreements, employee policy manuals, they were often left, seeing that they had holes in their business. And now, like you said, if they make different decisions, could impact what happens later on. So definitely a ripple effect there.
Yeah, but hopefully it's a learning point that people will take with them going forward.
Excellent.
That's something like Samantha was just saying that we've really come across in the last few weeks, is that there have been so many practice owners that, like she just said, they haven't had contracts or agreements. They don't even have handbooks. And now they've had to close their practice and send their employees home. So in this situation, what kind of liabilities do we need to be aware of right now or in the future when we can reopen our doors?
Yeah, it's a great question. And I agree with you. I think I would say the vast majority of dental practices do not have up-to-date contracts, policies, and procedures. And we often get involved when there's a purchase of a sale of a practice. And I still remember about a year ago where I was retained by someone buying a practice, and I said, you need to make sure you have good contracts, good policies. And the answer I got was, well, the current owner was really good about that, and they've got a policy book in place. And I said, great, just send it over to me. And he did, and I'm still not quite sure exactly what it was, but what scared me was the date on the first page, which started with the year of 19, not 20. So you can imagine how out of date it was. And it wasn't even really a policy manual. It was more of a sort of practice manual. It was almost how to upsell patients as opposed to managing the workforce. So there's a lot that can be done. Most businesses are not doing it. So what risks to be aware of? I'll use some slides to begin with. I'm a lawyer, so there's a disclaimer. So I'll remind everyone, not to copy these things, but more importantly, that date's actually wrong. That should say April 24th. But the point is this: a lot of the information that we were giving out 3 weeks ago is no longer accurate because of all the changes. So please, if you're going to look at this, it does not replace legal advice. Every situation is unique, but also things might change. And just on that point, just before I connected, I don't know if you guys saw this, but Prime Minister Trudeau announced rent relief for small businesses. And it's interesting because one of the points I've been making a lot lately is that we have the wage subsidies and the CERB and of course EI, and a lot of ways the government has tried to help out with staff. But a lot of businesses are in danger of failing because they can't afford to keep paying rent. Dental practices in particular, if you're shut down, you're still paying your rent. So there is relief available now, which may also have a huge impact on things as you go ahead. So that was my digression. How can you cut costs? These are sort of things we can talk about as we go, but the big one I want to get to is layoffs. Because as you said, Samantha and Olivia as well, initially we were talking about layoffs, and that was the gut reaction, is they were closing down, send everybody home. And most employers, and dentists are no exception, never really gave a thought to whether they had the right to do that or not. So this slide talks a bit about what temporary layoffs are. And just, the numbers there relate to the Ontario Employment Standards Act. But like I said, we work with clients across the country. So employment is governed provincially. So every province has its own employment standards legislation, just to make things a little bit more confusing. And they're similar but different. So in Alberta, for example, I know the numbers of weeks are a little bit different. But the principle is the same. The person is not working. They're not being paid. They are still an employee of the organization, and the employer can recall them, although they don't have to. But if they are recalled, then the employee must return to work. And I know we're going to talk later about return to work and things like that. But the other important point is that if you don't recall them within those timelines, then the layoff is deemed to be a dismissal, and you've now terminated the employment relationship. So there's two potential liabilities I want to talk about. One, and I'll flip forward here, is constructive dismissal. So I've been really vocal in the media for the last month or so about the fact that most businesses don't have the right to lay people off. And I know there's been some debate about that, but as I put on this slide, what is a constructive dismissal? It's a unilateral and substantial change to a fundamental term of the employment relationship. So what is the very fundamental basis of that relationship? It's that the employee will work and the employer will pay them for that work. So if the employer comes along and says, for the next little while, you're not going to work and we're not going to pay you, that to me is a substantial change to a fundamental term.
Definitely.
That's a constructive dismissal, and there is no automatic right. I know this is very confusing because, as I said, the employment standards legislation talks about how you do it. And the problem is it talks about how you do it. It doesn't give you the right to do it. That right comes from contract. So you read the news and you hear about Air Canada and WestJet and Cineplex with these mass layoffs, and everyone assumes that, okay, well, then everyone can do it. They're unionized. They have collective agreements. The collective agreements will have a temporary layoff provision. Some sophisticated employers will have contracts with temporary layoff clauses. And I will pat myself on the back here for a moment, because we've been working with a lot of employers for years, and we always recommend putting in a temporary layoff clause. And the pushback I usually get, and this includes dentists, is people who say to me, we don't do that. We don't lay people off. That's not our business model. And we usually say, please just keep it there just in case. We never imagine this scenario, but we've had a lot of clients who have called us and thanked us because there's no risk. They have the right to lay people off. If it's not in the contract, then you don't automatically have the right. We've had a lot of our clients, we've worked with them to go to their staff and talk it through and get their staff to agree to a temporary layoff or a wage cut. And if they agree, then you're good. You don't have a risk of liability. But Olivia, back to your question, if they don't agree and there's no contractual temporary layoff clause and you just impose that layoff, technically it's a constructive dismissal. As the last bullet says here, a lot of people have said that you can't take the existing laws and apply them to this totally unprecedented situation. And the point they've made is it's not fair. And I get that. I mean, if you're a dentist, you've shut your doors, you have no revenue, and now you're being told I've got to keep paying my staff. That doesn't make sense. It's not fair. But this wouldn't be the first time the law is not fair. It's entirely possible that a judge at some point in the future will say, yeah, you know what, we can't apply the law the same way. This is an exception. That might happen, but it hasn't happened yet. So as we've told our clients, you're rolling the dice. You might be okay, but if someone brings a claim, they might be successful, and then they'll be entitled to severance. And I know I've got some slides I can come back to if we have time about what severance might be, because it's usually a lot more than people think, and it could be up to 2 years. So that's one risk. And then the other risk is, like I was starting to say, we're getting to the point now where we're talking about the end of the timeline for temporary layoff. So what happens when you get there? What happens simply is it's deemed to be a termination. So, and what's important to remember is you can't contract out of the employment standards legislation. So even if the employee says, oh, I agree to waive that, that doesn't count. The act still applies. And it's still, technically, if you let somebody stay on layoff for too long, they're entitled to termination pay. They may not choose to enforce it. So you may be able to reach an agreement that way, but even that agreement, you can't hold them to it if they change their mind. So those are the biggest risks at this point anyways.
Absolutely. So just kind of going off of that last point you made. So as you just said, each province has its own provincial legislation about the time period for temporary layoffs. And generally when we hit that threshold, we might be processing terminations. So let's say hypothetically that if we do get to that threshold for temporary layoffs and we do need to terminate our employees, and of course, assuming that we process all of that correctly, then when we are given the go ahead to reopen, are we responsible for hiring all of our staff back?
Simple answer is no. And that applies whether there's still an ongoing temporary layoff or if you've reached the time limit and there's been a deemed termination. Like I was saying before, you don't have to recall employees from layoff. Now, if you unionize, and I know most dental practices are not, but if you are, there'll be a collective agreement and there'll be a very clear process. But assuming that's not the case, then first of all, you don't have to recall everyone. Second of all, there's no rules as to who or how you recall them. So this is an opportunity to basically get rid of the people that may not be the best fit in your practice. and you can recall some, but not everyone, or you can recall none or all. If it's during a temporary layoff, then you have the right to recall them. They have an obligation to come back to work. If you've reached that maximum timeline and they've been deemed to be terminated, then you're basically starting a new employment relationship, which is a great opportunity to put a contract in place, by the way. The other thing to bear in mind, though, is if you're not going to bring someone back, if you're not going to recall them, then there's a deemed termination. You're now on the hook for severance. And like I said before, and maybe this is a good time to go into this at least briefly. I think it's the next slide. So if you are deemed to have let somebody go, it's the same as if you just go and let them go directly. And you have to give them either notice or termination pay. And there's three potential sources of that. So the first is the employment standards legislation, which sets out the absolute minimum. And it's typically about a week per year of service, with some variations in every province is a little bit different. Key point here is that's the absolute minimum you have to give someone. There's also the common law, which says you have to give them reasonable notice. And contrary to the popular myth, it's not a month per year, it's not a week per year. It depends on a whole bunch of factors, which I'll skip forward and talk about that. Actually, I'm going to skip forward one more. It is an art, not a science. So despite the popular myth, there is no easy calculation, because our courts have said over and over again, they will look at things like length of service, age, the nature of the position, i.e. is it professional, clerical, sales, etc., the availability of similar work, things like inducement. If you lured a hygienist away from your competitor and then you let them go 6 months later, that their previous employment will be a factor, and anything else that is relevant. So just to give people an idea of the scope here, the unofficial max is 2 years or 24 months. So you can be discussing a substantial potential liability, and I'll kind of skip backwards here. The third point is contract. You can contract out of that whole idea of reasonable notice by having a contract which says, if we're going to let you go without cause, this is what you will get. And that's another reason why you need to have good contracts in place. Because if you do that, there's none of this. First of all, you can limit your obligation. But second of all, you can imagine that when we say someone gets a reasonable notice, what does that mean? So the way it typically plays out is if the employer, let's call it the dental practice in this case, if they're smart, they'll contact their employment lawyer, and they will give their employment lawyer all the data, and their lawyer will say, well, I think it should be between 8 and 10 months. So let's say they're being conservative, so they'll offer 9 and go right in the middle. So they'll offer that severance package to the employee. If the employee is being smart, he or she will go to his or her employment lawyer, and his or her employment lawyer might say, well, it should be more like 11 or 13 months. So now there's a negotiation, and if you can't agree, there's litigation. And who's winning out of all this? The employment lawyers. They're the ones who are being paid to negotiate and to litigate. So you can avoid all of that uncertainty with a really good termination clause in your contract. So another potential liability, Olivia, to your point, but also another reason to have really good contracts as you go forward.
Yeah, absolutely. Now that's a lot of information.
I feel like I'm talking a lot, so feel free to jump.
Yeah, no, it's fantastic. Now, one topic that I know everyone is really eager to talk about right now is the Canada Emergency Wage Benefit, or the CEWS, as there's been a lot of confusion and conflicting information about the CEWS. Some sources are saying that we should not be applying for it if our employees have been laid off and not able to do any productive work for the practice. Others are saying that this is a way that we can put individuals on like a paid leave of absence, regardless of any productive work being completed by the employees. So has there been any confirmation in the legislation about what is considered best practice for activating the CEWS?
Well, it's funny hearing you say CEWS. I've heard everyone say Qs up till now, so we can have a debate about that later. I think it's important to remember that, the intention behind I'll start saying CEWS now. The intention behind the CEWS is to avoid layoffs. And it was quite interesting because, like I said before, I was very vocal about 4 weeks ago now, about saying that layoffs may not even be allowed. And I'm not saying that I caused this, because I won't take that much credit. But it was interesting that a few days later, the government announced first a temporary wage subsidy, which was 10%. When they realized that was just not going to do it, they came up with the CEWS, 75%, which is a huge, huge game changer in my view. But the whole idea and what they are saying, the messaging is very clear. They want to avoid layoffs. And it was interesting that Air Canada had announced, I think it was 16,500 layoffs they then announce they're going to recall all those people and apply for the CEWS for all their employees. So what the intention here is that even if you don't have productive work for an employee, the intention is that you either don't lay them off or you recall them from layoff. And if you have work for them, great. If not, they can stay at home, but they're not on layoff anymore. And there shouldn't be any, they shouldn't be receiving any, they can be receiving income. I was thinking of the CERB, which is the other potential source of assistance. They can be receiving income. And the other messaging that's been very clear is there's an expectation that employers make their best efforts to top up that extra 25%. Now, what does that mean? That's still pretty vague. And the other interesting point, frankly, is the federal government has said you don't need to submit all the documentation with your application for the CEWS. So you're not going to have to prove all of the eligibility, and you're not going to have to prove right away what you're doing as far as paying your staff. But I'm encouraging all of our clients to maintain all the documentation, because at some point there's going to be a reconciliation, and you might be asked about what did you do. The worst thing you can do, and you guys are in Alberta, there was an Edmonton company who you probably saw this in the news. They basically announced to all their staff that they were all getting a 25% pay cut thanks to the federal government. That is just not the intention, not the way to do things. And if you want to attract the attention of CRA, that's probably a good way to do it. So we've told a lot of our clients, and dental practices in particular, if you are shut down, if you're not operating, if you have no revenue, then you're in a pretty good position to say, look, we could not afford to top up that 75%. So we didn't. But if you are operating, then you're going to need to be able to justify the fact that you couldn't pay anymore. Even if it's 1% more, you're going to have to justify that you couldn't do anything. Otherwise, it's not. I think it's not going to look very good if you just automatically say you're going to get your 75% up to $847 a week, and that's it. So I know that was another long answer, but the whole idea is to get people off layoff. It's not to put them on layoff. This is to avoid that.
Right. Absolutely. So now I guess a kind of a theoretical question or a hypothetical question. So these practice owners, a lot of them, they don't have any work for their employees that they can be doing from home, and they have zero production coming in. They've got zero revenues coming in. So a lot of them, if they have the clauses in their contracts, they are putting them on temporary layoff. But we are getting kind of close to the end of that period of temporary layoff that is allowed by provincial legislation. So with that being said, as we near closer to the end of the temporary layoff period, is that the time that they should think about recalling their employees and trying to put them on the CEWS, or is that allowed, or what are your thoughts on that?
Yeah, it's a great question. And just to get to the last part there, it certainly is allowed. So there's a couple of points. I mean, we haven't heard anything about this yet, but I think as we're going to get closer to the end of those timelines, I'm assuming that our governments are going to step in and consider amending legislation and basically buying more time for everyone, because it's pretty clear that most businesses are not going to be back operational within the next few weeks. So A, I think the legislation may change. B, and this varies from province to province, but in some provinces, the timelines are extended if you do things like continued benefits or top up employment insurance benefits. So for example, in Ontario, the default is 13 weeks, but it can be 35 weeks if you continue benefits or top up EI. So that's something to consider if you're not doing it already. Otherwise, I think you're right. I mean, otherwise, I think, you've got two options. If you're hitting up against that deadline, then you can either recall them and take advantage of the CEWS, assuming that you're eligible and the employee is eligible, or you can say, you know what, this is not an employee that we need, so let's just go with the deemed termination and go down that road and assume they're never going to come back. Maybe, depending on how things go, you rehire them in the future, but assume that you're just bringing it into the relationship at that point, which of course exposes you to the termination pay liability we talked about. So it's not a great solution, but it's an option.
Right. Absolutely. Well, thank you very much for all of that valuable information. The CEWS has been an area where we receive many questions about what best practice is. And it's nice to hear that we still don't know across the board. Best practice is still a little bit of the unknown. So that's been very informative.
Weeks. Oh, sorry, I didn't mean to talk over you, but I feel like we've been saying we don't know for weeks, and more information has come out. And just to make sure everyone knows, the portal is supposed to open on Monday.
Yeah.
So make sure that if you are going to apply that you're ready and you have your My Business account open on the CRA website, because the portal's opening and they're saying the money will start flowing May 4th. I'm a little skeptical that it will, but hopefully it won't be long after that.
Yeah, I think like one message that I think we can hopefully people who are watching can take from this is that these are uncertain times, but the key factor is ensuring that we have protocols, we have the necessary things in place to mitigate our risk, because I'm hoping, I'm knocking on wood, that we never go through a global pandemic again, but chances are that we may have some other form of a crisis management that we are going to have to navigate through. So if there's anything that we can take from this, is just learning how to be proactive, learning what we can do to future-proof our business for any other situations that come up. But I guess with that next item is we kind of want to transition and start thinking, okay, the end is coming where we may have to reopen soon. Right. And I know some provinces, there's some talks about perhaps that being in May 8th, so in a couple weeks, let's just say. So what do you think practice owners should be starting to think of to prepare to reopen their doors?
Yeah, and I think that's. I'm glad to see that's where we are. That's where the discussion is. I think that's encouraging. So, I put up a slide here on keeping workers safe, but before I even get to that, it gets back to something we've talked about a little bit already, which is deciding which workers you want to bring back. Mm-hmm. So that's, and every business owner, whether you're a dental practice or otherwise, you'll need to assess your needs. How many people do you need? Which roles? And then unless it's 100% of your workforce, then you'll assess who you want to bring back. And like I said before, in most cases, you will have the flexibility of picking and choosing who you want. So that's the first step. The other thing to think about in the meantime, and I know we talked a bit about this off air, now is a great time to plan for the future by putting really good contracts and policies together. And I get it. I know that a lot of our clients, when I talk to them about what I always call our HR checkup and reviewing all of your policies and contracts, and they always say, yeah, I know, but I don't have time, I'm too busy. And I can understand that. Certainly now's a great opportunity. If you're not busy, if you're shut down, or if you're just dealing with emergencies only, now's the time. And if you have an office manager, there's no reason they can't be working. And they can be helping you with things like the office policy manual and working with someone like you guys, with ourselves, because you want to have really good contracts in place. So when you're going to recall people, first of all, it'd be great to have an updated policy manual ready. You don't necessarily want to impose, no, I shouldn't say impose. You don't want to necessarily implement a new contract right at the time of recall, but it's something to think about, and certainly for new hires. Before you hire anybody else, have a really good contract, and we'd be happy to work with anyone to put contracts in place. And we usually do, a few different templates. We'll have a template for associates if you have any. We'll have a template for other professionals, and we'll have a template for hygienists, a template for office staff, office manager, whoever you have in your workplace will have those, and they're ready to go. So before you hire anybody else, you've got a good contract with a good termination clause, temporary layoff clause, and everything else. And then on your policy side, there's a million things you can do, and you guys can talk to that more than we can, I'm sure. But certainly health and safety. How many of our respective clients don't have up-to-date health and safety policies in place? And all of a sudden, this is a huge issue. And as well, remote work. And this, doesn't necessarily apply to dental practices overall, but still, again, your office manager might be able to work from home, some of your staff calling patients, etc. But do you have a policy as to what has to be done, what equipment they use? Do you provide equipment? Do you pay for their equipment? How do you monitor their time when they're working from home? All these things should have policies in place, but most practices don't. So those are things to think about. And then when you start operating again, keeping workers safe. And the starting point here is every employer has a duty to provide a safe work environment. And traditionally we talked about that as in like loose floorboards and things like that, not having nails sticking out of the wall. Now it's a very different conversation. First of all, harassment's a big part of safe work environment now, and you need to have a really good harassment policy in place. But more to what we're going through now, having policies in place for social distancing, working remotely, as I said, protective equipment. And when I say social distancing, between staff and patients, and patients. and also being aware of the right to refuse unsafe work. And I'm curious if you guys have heard of this much. Yeah, it may be too early because most practices aren't open, but I've had a lot of clients who have said they either are operating or they're starting to operate again, but they have employees that say, no, I'm not leaving the house. I'm scared to. And the question we get, of course, is, do they have the right, or what can we do about that? So I'm curious if you guys have seen that as well.
Yes, definitely starting to get those questions come through. And, I guess along those lines is, what's the legal right for the employee, and then also for the employer as well, because they need to continue on business. So what would you say if somebody kind of came to you with that aspect?
Yeah, I was hoping you'd ask me that. It's happening a lot. And so a couple of fundamental points. I mean, first of all, as we said, employer has a duty to maintain a safe work environment. Conversely, the employee has a duty to come to work when they are told to come to work, if they're recalled, etc. The only exceptions to that would be either if there's a job protected leave. So I know every province has changed their leave somewhat to reflect COVID-19. So if they are in a period of self-isolation, if they have to be home to look after family members, there may be job protected leaves, in which case they are entitled to stay home. Not necessarily paid, although in Alberta, actually, it's more generous than some. There is a paid leave. There may also be human rights accommodation things to consider. So if there is a human rights reason for them to stay home, then they would be entitled to. Absent those reasons, the only other reason would be that they have the right to refuse unsafe work. So this always exists, of course, where someone can say, I feel as though I'm unsafe at work, and therefore I refuse to work, basically. And usually the way that would play out is they would, typically speak with the employer or HR or whoever the person in charge of safety is. And if they can't agree, you'd call the Ministry of Labor. The Ministry of Labor would send an inspector, and they would assess it. I know, again, in Ontario, they've added a lot of inspectors, and they've expanded the number of hotlines available to deal with these issues. But what it comes down to is this. You can't refuse to work just because there is a pandemic and just because you feel unsafe leaving the house. You can refuse to come to work if there is a legitimate, objectively justifiable fear of that you're unsafe in the work environment. So, I'll take a silly example. If you're being forced to work next to someone who tested positive for COVID, that's an easy example of someone where no one's going to be expected to work in that scenario. But otherwise, the onus is going to be on the employee to show that it was unsafe. Otherwise, the expectation is that they come to work. And you don't want to go down this road necessarily, but if you have to, then you should consider it, of imposing discipline and basically saying that if you don't come to work on Monday, we will, you might get one more warning, but short of that, we're going to assume that you've abandoned your job, in which case your employment will come to an end. So hopefully it doesn't come to that. And at the same time, I've had some employer clients say, well, that's fine because we don't need everyone back anyway. So that's one person who we can put on layoff, and they don't want to come to work, so they won't fight it. So you can be strategic as well. Obviously, document it very clearly, because you don't want them to turn around 6 months from now and say, well, I wanted to come to work and you told me I had to stay home. But if you do document it, then that's one way to have a layoff and cut your costs without any risk. But otherwise, like I said, the starting point is they have to come to work.
Yeah, definitely. And I think kind of narrowing it down, if we could, to that one point of yours, is we need to have that proof, right? So if an employee is saying that I don't feel safe in working in this office, and then if an investigation comes into place, what do you have in play? Do you have an occupational health and safety? Have you documented that they've gone through infection prevention control methods and specific trainings and understand the protocols and have signed that manual? So it all goes down to, if it's not documented, it never happens. So making sure that all of those things are in place beforehand. And so I kind of want to follow along with those questions, if that's all right, in terms of, let's say, for example, an employee is, we have a question here from Isabel. So what can employers do once this is all over and employees decide to start traveling? And if, or if somebody is coming saying that they potentially might be sick, or if somebody else is sick in their area, like what are the steps? So in that way we can contain that, so we don't have any traces, perhaps, of us, our dental practice being a source of spreading COVID-19.
Well, that's a great question. It's so funny because at the very beginning of all this, it was funny because we did a webinar, I think it was March 17th, and a lot of the focus was on employee travel. And then, of course, all travel stopped. So that just became irrelevant. So it's interesting that I haven't even really thought about it until you asked that question. But you're right, we're going to come back to that. And I was thinking about it too this morning because, of course, we hear the reports every day. Some companies, the numbers are going, some countries, the numbers are going up, some countries are going down. And I was thinking about that and what's going to happen once businesses reopen. And what if you have someone who wants to travel to certain countries? So again, it comes back to the very fundamental point. You have this obligation to maintain a safe work environment. So if you're going to have employees traveling, because of course you can't stop people from traveling if they have vacation time or whatever, but you can refuse to allow them to come to work. Now, here's the interesting thing. If they can't come to work, for example, if the government mandates a self-isolation period, then they're the ones who are preventing themselves from working. You don't have to pay them. But if it's your policy, if you're saying, well, technically you're not required to self-isolate, but we're saying to stay home for 2 weeks, then you would have to pay them because that's your decision not to allow them to come to work. So that's one aspect. The other aspect is protective equipment and maintaining, you mentioned policies, which is critical. The other point is, making sure that in the COVID-19 world, that you are meeting the expectations as far as cleaning equipment, cleaning any surfaces, basically maintaining social distancing as much as you can, because the moment that you fail in any of those, it's going to be easier for an employee to say that it's an unsafe work environment, therefore I'm entitled to stay home with pay. So I'm not sure if that fully answered your question, but that's sort of a few of the thoughts that I had on that.
No, thank you for that.
Yeah, and we're seeing more and more practice owners too. They're starting to wonder about how they can actually make sure that their employees are healthy when they come into work. So they're talking about, infrared thermometers, or can they have an employee sign a declaration that says that they are healthy and fit to work? Are these things that are now going to be legally allowed? And what about patients? Can we do the same for patients? Can we check their temperatures before they walk in the door? Like we're seeing grocery stores doing it. So what does it mean for practice owners?
Have you seen grocery stores checking customers?
In Vancouver, yeah.
Really?
Yeah.
Oh, wow. Interesting. And obviously somewhat beyond my area because that's not employment law, but in any event, I mean, the point, the issue is an interesting one because we've always had this tension between the duty to provide a safe work environment and the privacy rights of employees. And so generally speaking, the privacy rights mean that you cannot intrude upon someone's privacy any more than is reasonably necessary to achieve other goals, such as providing a safe work environment. So, I mean, up until a month and a half ago, if you had asked me, could we check the temperature of every employee before they step through the door, I would have said absolutely not. Mm-hmm. Now, as we know, a lot of businesses are doing that, especially in sort of food production, that area. But it makes perfect sense in the context of a dental practice. So look, there's no definitive answer to that question, but in my view, it's certainly defensible. And I think what's important is that you're going to have to explain A, why it's a reasonable thing to do, and B, that there is no less intrusive way of achieving whatever the purpose is. The purpose here is obviously keeping the work environment safe. So if there was some other way to do it, and I guess that's where the argument might be. You mentioned, getting a sworn affidavit or document. Would that be enough? Because that's obviously less intrusive than temperature testing. But would that be sufficient, or would you be able to rely upon those? And I certainly don't have an answer to that question, but that's the analysis you'd have to go through. I would think personally that when we're talking about a medical dental professional office where you're treating patients where obviously there's very close contact, temperature testing doesn't sound unreasonable, but that's my personal view. That's certainly not an opinion on the law, but that's the analysis you have to go through is explaining why it's justifiable.
Right. No, that was a great question. And I just want to circle back in terms of, thinking about bringing back on our team. You'd mentioned, the process of recalling the team. Is there a specific, I don't want to say strategy, but is there something that we need to keep in mind to determine who we can bring back? Is it based on seniority? Is it based off of how do we make sure that if we bring, let's say, for example, it's 25 employees that we have in our office, but maybe at the beginning, we might not be to maintain social distancing, we might not be able to have 25 employees plus the dentist plus patients. So maybe we can only bring back a limited amount of employees. And how do we determine who that's going to be without stepping on any toes and having somebody say, well, that you're bringing them back because of age or race or what have you? So how do we tread that fine line there for that?
Yeah, you covered one of the points I was going to make. I mean, so it's a great question. And sort of all, it's hard to avoid treading on toes, as you said. That's the whole issue, other issue aside from the legal issues. But again, assuming you're not unionized, there is no rule, there is no required order. But I get this all the time when we have people come to our office, obviously pre-COVID-19 era, where, certain people were let go and others are upset because I was there longer, so why did that person go? Or I was there longer, so why did they bring that person back from layoff? But the bottom line is, employers can it's kind of like hiring. You can hire anybody you want for any reason you want or no reason at all. It can be as silly as saying, I'm not going to hire anybody who wears a tie to work, or I'm not going to hire anyone who comes in a blue jacket. These can be ridiculous reasons, and it may not be a great HR practice, but there's nothing unlawful about that. It becomes unlawful if, as you were suggesting, Samantha, if it's based upon age or race, disability, and we should say this, COVID-19 has been confirmed by human rights commissions to be a disability. So you can't refuse to you can refuse to bring them back if they are positive, but you can't fire someone because they tested positive. But aside from human rights grounds, you can bring back whoever you want in whatever order you want. And that's part of your prerogative as an employer. You may still step on people's toes and get people upset, but that's not unlawful.
Okay. No, thank you for clarifying that for us. So I know we've definitely covered a lot in this last little bit, but now that we've kind of been looking at what can we do now to prepare to reopen, getting employment contracts, ensuring that we have a safe work environment. So having an occupational health and safety, providing all the necessary trainings. And, I'm going to go back to what you mentioned before about having a good employee handbook and those policy manuals in place. But have you noticed any other issues that could have prevented, what we've seen with COVID-19? Do you think there's anything that we could have done to kind of prevent or prepare for this type of disaster?
There isn't really anything else, but it's just kind of, I guess, fine-tuning some of the details there. It really does come back down to contracts and policies and procedures. And obviously we can never prevent a lot of what's happened, but like we've touched upon, if you have a really good contract, you would have been able to breathe easier if you're imposing layoffs and not having a risk. If you had a really good contract with a termination clause, then you would know that even if you can't bring people back, your severance obligations are minimized. If you have really good policies, then you wouldn't have to worry about someone saying, well, it's not a safe work environment because they don't even have a health and safety policy, for example. And again, remote working. And, this applies to a lot of other businesses more so than dental practices. But again, even the dental practice, we've had a number of clients where the staff have been working from home and calling all the patients. And at first it was just canceling appointments or rescheduling appointments. But lately it's just been keeping in touch with patients. So there are things that can be done. Office manager as well. So having a really good policy on remote work and use of equipment. And what about, it's been interesting because, there are a lot of our clients who give out, cell phones to their staff. What can they use it for? And can they use it now even when the business is not operating? So a lot of it comes back to those points. And I'm curious to know if you have a better answer, because to me, it all comes down to the contracts, policies, and procedures. I'm not sure if there's anything else that you can think of.
No, you covered all of those bases, and I see Olivia, you've unmuted yourself, so I know you wanted to jump in here. So
thank you. Something that we're seeing though is a lot of these practices, they're thinking, okay, everybody's been laid off. I'm going to relook at my contracts. This is a great opportunity for me to initiate a new contract. Or if I didn't have any contracts, and of course we're always saying, whoa, what is the consideration that you need to apply to those sort of things before you jump the gun on that one? But what kind of advice would you have for that sort of situation?
Yeah, great question. I'm not sure if I have a slide on that. I'm going to check really quickly. Not so much, but I can certainly talk about it because this is a key point. And I have this discussion with people all the time where I explain the benefits of really good employment contracts. And when people understand that and they say, okay, I got it, we're going to use them for all of our future hires, but what about our existing staff? Can we get them to sign? And the answer, as you mentioned, the key is consideration here. So taking a step back to my contracts law course of 25 or so years ago now, as I still remember the example my contracts prof used to use. And he walked into class one day and he said, here's the difference between an enforceable contract and a gratuitous promise. He said, if I walk in, and he picked one of the students in the front, and said, if I say to you, I'm having such a great day, I'm in a wonderful mood, I'm going to give you $100. And you say, I accept. That's a gratuitous promise because I'm giving you something, but I'm not getting anything in exchange. To make it a binding contract, there has to be some benefit flowing both ways. So as he said, if I walk in and I look at one of you and I say, that's a great shirt you're wearing, I'll give you $100 for it. And you say, I accept, that's a binding contract. There's an offer, there's an acceptance, and there's a benefit flowing both ways. So how does this apply to the employment law relationship or the employment relationship? Normally, the quid pro quo at its very heart is I'm going to offer you a job and you accept all of the terms and conditions in whatever contract we discuss. It might be verbal, it might be written. Just to be clear, contracts don't have to be a formal legal document. I mean, it could be a one-pager, it could be a handwritten note, it could be on the proverbial cocktail napkin, or more often than not, it's verbal. And the problem with the verbal agreement is you'll typically talk about some things, right? What is the role going to be? Maybe their duties a little bit, compensation, vacation. That's usually about it. And then the law will imply a whole lot of other terms like that duty to provide reasonable notice of termination we talked about before. All that becomes part of the verbal agreement. So the challenge is if you already have an agreement in place, maybe it's verbal, maybe it's a short one pager, but it's not what it should be. How do you put a new contract in place? And Olivia, you said it, consideration is the key. So the test is not whether they sign, it's whether it's enforceable. To make it enforceable, you've got to give them something of value. And I had a great discussion years ago. I was chairing a conference and we had a judges panel and we had 4 judges and I put them on the spot at one point and I said, okay, we know that consideration is something of value, but what does that mean? What's the minimum? Because that's the question we usually get, right? What's the minimum I have to give someone to make it enforceable? And I always say, well, there is no absolute rule. It's got to be something of value. So at this conference, I asked them and I said, well, what about $1? And they all laughed. And I said, what about $10? And they all laughed. I said, what about $100? And they laughed a little bit less. So you can kind of see how the conversation went. It can be, the best opportunity to put a contract in place is either when you're going to give someone a promotion or an increase in pay. That's an easy one. You can say, we're going to promote you to be the office manager. We're going to increase your salary if you sign off on this new contract. So it could be a promotion, increase in pay, new benefits. I actually had a really creative client a few years ago, they're in a dental practice, and they didn't have benefits at that point, but they wanted to bring in a new, really, really good benefit package. So I said, this is perfect. So the deal here is if you want to be on the new benefits package, you have to sign the contract. And it worked very well. I think they had about 14 employees and 12 signed right away. 2 said thanks, but no thanks. So you had 12 on the new benefit package, 2 without. But within 6 months, one of the holdouts had left and the other one signed. So that can work well. It could be a one-time payment. We're going to give you a week's pay. We're going to give you an extra week of vacation this year. We're going to give you $500. Something of value will make it enforceable. The other way to go, and it's not one I like that much, but it can work, is giving somebody notice. And the way this works is you need to tell them that effective on a date in the future, this will be your new contract. The problem with, 2 problems with doing that. A, they never have to sign, so it's not as clean as I would like it to be. But second of all, the amount of time involved, basically what you're doing is you're terminating their existing agreement and you're starting a new one, which means you have to give them the same notice that you would as if you were letting them go. And as I talked about that before, that could be months or years. So you could be looking at a year and a half, 2 years down the road. And basically the message is, if you're still here on that date, this will be your new contract. Theoretically, that's enforceable and that works. It's just, A, it takes a long time. B, it's not as clean. And C, people don't like having things imposed upon them. They'd much rather feel as though it was a negotiation. So I would definitely try to go the consideration route as long as you give them something of value and you make it really clear. I mean, you guys both said it, documentation is critical. I've seen too many employers mess this up by giving somebody a promotion and then trying to have them sign a contract. It's got to be a quid pro quo. You don't get one without the other. And if you do that properly, then that's the best way to put yourself in much better shape.
Yeah, no, definitely a lot to consider when it comes to the employment agreement. It's not just something that, hey, I decide because I didn't have it before, I want to do it now, and completely changes the game. So definitely a lot of things to consider. I know we've really grilled you down the last 50 minutes with a bunch of questions. Are there any like key takeaways that you want, these business owners to be watching right now, apply it, and then also being able to see the benefits later on down the line?
Yeah, no, thanks. And I wouldn't have called it grilling. It's been a fun discussion. But I mean, really, I think we've made a lot of the key points, and it starts off with, I always remind everyone that you might think you're hiring someone and adding to your team, which is true. I think you're creating a legal relationship. So just remember, every employment relationship is a legal relationship. There are legal rights and obligations, some of which are imposed by law and you can't avoid. But it's also important to remember that our employment laws are designed primarily to protect employees. And there are some things you can't avoid, like employment standards minimums. But there are a lot of things you can change. And we talked again about severance. We can dramatically, give you the most extreme example. Let's imagine you have an office manager who's with your practice for 30 years, and they're now in their mid to late 60s, and you're going to sell your practice, so you need to terminate their employment. If there's no contract, they're probably going to get 24 months of severance. If you have a good contract, that could be as little as 8 weeks. So it's a massive difference. And it doesn't have to be that difference. I should make this clear. Using a contract doesn't mean you have to be so onerous. You can be fair, but have it be a little bit more reasonable and have it be in black and white. But anyways, my point, to your question, Samantha, using, every employment relationship is a legal relationship. You should have a good contract. You should have the policies. You should be strategic. And then anytime you make a decision, and I'm talking about anything from hiring, from discipline, dismissal, buying a practice, selling a practice, if there's an accommodation request, if there's a harassment complaint, anything that impacts that employment relationship, make sure you understand the legal rights and the obligations that arise and the implications, because that's what gives us most of the work that we do. It's when people don't have that understanding and they come to us because they've now received the nasty demand letter from someone's lawyer, or they've received the complaint, or they've received the statement of claim, and they never turn their mind to potential issues before that time. You've got to be strategic, and there's a lot of ways to do it. It doesn't have to be expensive. But it's kind of like insurance. There's an upfront cost of time and money, but it'll save you a lot of heartache and a lot of money in the future. So that's, to me, the overriding message. And COVID-19 is just a reminder of that, and also an opportunity, because a lot of people have some time on their hands at this point to be a bit more strategic. So working with folks like you guys and firms like ours, it's a great opportunity.
Yeah, I couldn't have said it better. And I think the key word that you kept mentioning was strategic. And that is important as a business owner. It's not always going to be the same plan A for everything for the 30 years that we're going to be in business, or being, a practice owner, right? So there's going to be different changes. We're going to have crisis like this, which is essentially a period of accelerated change that's forced upon us. Right. So we have to be ready for that. And we have to make sure that our business is prepared, because there's nothing worse than, having a change upon you and you don't have your game plan. At least with something like this, you've got plan A to plan Z, right? So it goes all the way throughout that, and the evolution as we continue growing and adapting in our business and overall overcoming all of this. So I really appreciate you taking the time today to speak with us, to go over all of these points and, really help these practice owners now, like you said, that they have the time to be able to see what do we take away from this? What do we ensure that, if there was any sort of disaster in the future, how am I going to mitigate my risk? How am I going to take care of my business? How am I going to keep my patients and my team safe? throughout all of this and really have our strategy for that. And we don't have any questions aside from the one that Isabel had asked earlier. So you've done a fine job answering all of that for everybody. So again, how can people reach out to you if they have any more questions?
Yeah, thank you. And hopefully I didn't do a great job of confusing everyone. That's why there's no questions. But the last thing I'll say, first of all, keep up to date. We've had a running blog since roughly around March 20th. So we add to it. It was 5 or 6 times a day for a while. It's slowed down a bit. But if you want to keep up to date on everything COVID-19 workplace related, then please check out our blog, which you can see on the screen now. But more importantly, just to keep up to date on things generally, there's lots of ways to find us. So if you want to find us, I don't think you have too much trouble. But we do have a very active blog. We have very active social media. We do an online show once a month. It was actually just a couple of days ago, which you can watch online. So I encourage everyone to keep up to date. Feel free to reach out and sign up for our newsletter. We promise we will not inundate you with email, but it's typically once a month with a bit of an update on what's happening in the world of employment law. But the last thing I will say, and it's become a bit of a catchphrase on my show, is if you think you might need an employment lawyer, you probably do. So feel free to reach out to us. And there's never any harm and no obligation. So if we can help you, great. If we can't, no harm done. And the other catchphrase I've used for a while now is it's always less expensive to prevent a problem than it is to fix it. So better to reach out sooner rather than later. And the same thing applies for you guys. You guys do provide a tremendous service on that strategic side as well. So get the help you need when it comes to the employment relationships, ideally sooner rather than later. And feel free to reach out to us. I'd love to talk to anybody who's watching this either live or later on.
Agreed. Well, thank you very much, Stuart. I know we refer, all the employment questions from our clients and send them your way. So thank you again for being such a support, not only to us, but to our industry. And I know you've been so busy over the last 6 weeks answering questions. I've been, following on your blogs and watching all your videos. And I know you've been busy being all over the internet. So thank you again for everything that you've done to really help answer all those questions for us today.
No, thank you. You guys are a great resource as well. So I'm really glad that we met a few months ago, and hopefully we'll continue that relationship. So thanks for having me on today.
Thanks again. Have a great day, everybody.
Take care. Stay safe.